and welcome to the COVID-19 Your Questions Answered, a webinar series addressing your most pressing questions about the coronavirus pandemic. My name is May Mokdad. I'm a Regional Director for the Condo HOA Division at FirstService Residential. Joining me today, we have Edwin Lugo, Vice President of the High Rise Division with FirstService Residential.
Good morning, everyone. Thank you.
We have also Jonathan Mofsky, Esquire Shareholder at Siegfried Rivera.
Hey, good morning, everyone. Thanks for the introduction, May. Before we get started, I'd like to just take a moment to initially address a few items related to this presentation. Primarily, I want to share that I am a specialist in Florida Community Association law. And for that reason, we will be addressing these subjects as it relates to and under Florida law. We will be talking about some proposed guidelines, procedures, and legal issues related to the COVID-19 crisis. And as I'm sure many of you can appreciate, we are in some uncharted waters here as it relates to many of these issues. And for that reason, it's important to consider consulting each association's counsel on any subject matter we discuss herein. It's also important to consider that the circumstances surrounding this emergency health issue that we all face are ever changing, and they develop regularly, in fact daily, and so we have to keep that in mind when we are discussing and establishing community association policies and guidelines and evaluating these issues.
Those are some great points, Jonathan. I completely agree. As North America's property management leader, FirstService Residential is closely connected to the coronavirus outbreak and its impact on community associations. We shared some valuable insight with everyone during our comprehensive 90-minute webinar titled Navigating Coronavirus in Your Community. In the weeks since, we've received an outpour of questions regarding things such as community access, financial related concerns, how to keep the residents engaged during a shelter-in-place order. An overwhelming number of those questions were about associations' need for legal perspectives and what can they actually legally do. So this is the purpose for today's call. Okay, let's move on to the next slide. What emergency powers do board members have during this pandemic?
Well, let me start with the Florida Department of Business and Professional Regulation weighed in a little over a month ago on this issue and issued an emergency order. And for those that are attending, it's 2020-04 in response to this COVID-19 crisis. It was clear, I think, at least in my opinion, that the statutory emergency powers for condominiums and homeowners associations were drafted and intended to apply in the circumstances of a hurricane and the like, that type of casualty event. And with the issuance of this emergency order, the Department of Business and Professional Regulation has invoked certain emergency powers in favor of associations. I say certain, not all of the emergency powers. So it's important for board members and management to familiarize themselves with this emergency order and the extent to which the emergency order applies. I'm not going to go through all of the provisions because of limitations on time. I'll mention that for condominiums, the section of the statute is 718.1265. It's subsection 1, paragraphs A through J. So the only powers that have been invoked by the issuance of the emergency order are A through J for condos. For homeowners associations, the statutory section is 720.316, subsection 1 again, and it's A through H. So A through H for homeowners associations and A through J for condominium associations. To talk about 2 or 3 more significant emergency powers that are now available by the Department of Business and Professional Regulation to condominiums and homeowners associations. We have the cancellation and rescheduling of meetings. We've seen that become important in the context of holding membership meetings, particularly annual meetings and elections, where there are typically large gatherings of people and voting that's required, and certain procedures that have to be adhered to in order to conduct those meetings. And so those meetings now under the emergency powers sections can be addressed differently. We also have certain limitations and restrictions on access to areas in the community, and limitations on access to the areas and closure of those areas, and the ability to conduct meetings in a manner as is practicable. That is to say, if there's the threat of an emergency and it wasn't foreseeable, maybe conducting an emergency meeting with limited notice. Again, these emergency powers should only be utilized given the threat at hand. And so there needs to be, reasonable justification for the use of the power at issue, and a nexus between the issue that's being faced by the association and the power that's being invoked to address that issue. Going back to the limitations on the powers, there were two specific items that were not addressed in the DBPR's emergency order. They're both financial related. One is, interestingly, that special assessments cannot be established without a unit owner vote. That is to say that under the emergency powers, normally, if those powers were available, an association could afford itself of establishing a special assessment through the board vote without a unit owner vote that might normally be required under the governing documents. The same applies to borrowing. The borrowing section of the emergency powers under the statute for both condominiums and homeowners association was not referenced in the emergency order, and therefore would not be available as an emergency power to associations. An important consideration for all associations out there in Florida is that there's a caveat in these statutory sections, and that caveat is powers are only available to the extent that they're not specifically prohibited by the association's governing documents. And so just another point why it's important to work with the association's legal counsel on all of these sort of unprecedented issues is that it's important to review the governing documents to see if they address a restriction or a limitation or the extent to which emergency powers can be invoked. As to some practical and operational matters, I'm sure that Edwin has seen, these powers utilized maybe in the context of meetings and different things going on operationally and challenges that associations are facing from a managerial stance.
So thank you, Jonathan. I definitely have to chime in on that one because from an operational perspective, our number one priority is the safety of our residents and our associates. And the best way to ensure this is through our most powerful tool, which right now is communication. Communication is key. Buy-in is key, and explaining to our boards and our residents and our staff the importance of cooperating with the boards and management's measures and mandates are critical to fighting this invisible threat. We'd like to issue frequent updates, either daily or weekly. Continue holding board meetings, but from the comfort and safety of your own home, and keep them regular as you would in the normal course of business. And really conveying to the community that you're in it together as a board. These same measures are impacting them equally, right? No one is above reproach. This is something that everyone is in it together. And of course, closures, right? We've had to limit the areas that our residents and our staff and of course our board members traverse through, right? Early on, we closed off amenities to control the spread. We maximized cleaning and disinfecting supplies, and we limited our focus to lobbies, corridors, elevators. We marked off areas, limited elevators to 2 people or occupants of a single unit, and limited access to essential guests and deliveries to lobbies only. There are just so many things that we enacted at the very onset, and we continue to uphold. And thankfully, we are seeing a lot of our residents comply and understand that this is for their own good.
Thank you very much. If you guys don't have anything else to say on that, let's move on to the next slide. Can we legally require the 14-day self-quarantine mandate for those who voluntarily advise that they've contracted the virus? And if they violate the quarantine, can we legally enforce?
On the first question, we can and we should require the 14-day self-quarantine mandate. Those individuals, this slide relates to individuals who we know have contracted or been infected with the virus, right? And for that reason, those individuals pose a foreseeable risk to all of the staff in the building and all of the residents in the building. Not only directly, but in relation to the areas that they come into contact with and that residents or staff may subsequently come into contact. So as a director, we're putting on our fiduciary hats and we're acting in the best interest of all owners. And we're taking steps to reasonably protect the health, safety, and welfare of the residents. And for those reasons, we should be establishing procedures where owners know that they need to quarantine and are indeed quarantining. The second question deals with violating the quarantine, if we become aware of that. Certainly there are enforcement mechanisms. Number one, it gets reported to law enforcement. Number two, it's getting reported to the Department of Health. Number three, there's emergency action, emergency lawsuits that can be filed for injunctive relief to, preclude the person from the building, to preclude or to mandate that the person remain in their home during the required quarantine period. None of these are ideal. Nobody wants to deal with the situation, not even the infected individual. And so fortunately, what we are seeing is a lot of civic mindedness. People are really aware of the impact that this virus has on not only themselves, but on other people health-wise, but also on the legal impacts that their actions or inactions can have on themselves by virtue of what they choose to do or not do under the circumstances. And so what I've found most is while a person may initially take issue, right, and say, well, quarantining means I can leave. I can still go to the grocery store for my essential service. Once we advise them in writing of the consequences of that decision, they quickly heed to what we request because they don't want to face a lawsuit and they don't want to face damages that they could sustain by virtue of harming other people. I see this affecting not only legal issues, but operational issues throughout associations. How do we advise the owners, the residents that are in our community to quarantine? What can we do as an association to help them so that they don't have to go to that grocery store I mentioned, or so they don't have to worry about it? Edwin, I'm sure you can share some points on that subject and what communities associations should and are doing as it relates to assisting owners through these tough times.
Yeah, absolutely, Jonathan, and thank you for that segue. At FirstService and hopefully at other communities as well, not managed by our company, your board and management, we're here for you, and that's been our campaign this entire time, these past few weeks, just being here for you. And we don't want to be in a position to have to enforce legal means by any means on our residents. These are definitely and certainly uncertain and trying times, and we recognize that many are scared. Some not so much, which goes back to my prior point of communication. It's all about helping everyone understand the importance of cooperation for their own safety and that of their friends and neighbors. And with that comes a big component is confidentiality, right? Along with safety, the security and privacy of our residents is extremely important. We appreciate residents advising us of their situation for everyone's safety. We understand their concern for their well-being, and we are as well. So we want to be there, and our way of doing that is by supporting them, right? Supporting them, our boards, our residents, and our staff. So we'll make sure to keep that information confidential and work with our residents to support them through this unsettling time in their lives and make accommodations for special handling, deliveries, trash pickup, frequent cleaning and disinfecting of their surrounding areas, all to ensure that there is no need to violate quarantine. Because at the end of the day, that's really what's important here. Just stay at home, be safe, and let us do a lot of the heavy lifting for you in that regard. How about you, May? How are things in the HOA world?
I completely agree with you. And that's how we're managing our communities that are, I have some condo and high rise as well. But it's a little bit different with HOA. We have homes and they're spread out. So there's a little bit more playroom for the residents that are quarantined. But I have had a couple questions that came up. For example, residents have called complaining that their neighbor is supposed to be quarantined, yet they're hanging out in the backyard or in their front yard, in their driveways. How would we address that, Jonathan?
Great question. These are indeed some uncharted waters. All right, and I think what you're illustrating is a one-size-fits-all approach really doesn't work with this pandemic. An HOA, like you've described, really has a different setup, and there's the lot or the parcel that the individual owns. And there's the ability of that person to be outside on their property that they own while adhering to social distancing and other requirements. And so they're not out and about. And so in their mind, and under the orders, arguably, they are social distancing, and they are heeding to isolation or self-quarantine. And so the distinction that you're drawing really here is an important one. And that type of setup, should reasonably be approached differently than that of, the high rise or even the low rise residential condominium, where the owners or residents are living in close proximity to one another, where the door may be right next to the neighbor's door, or there's the shared elevator on the floor, the shared hallway. None of which would present as issues in the scenario that you just described. Now, you may have the situation in that community, that homeowners association, where there's a gate, shared gates, right? Shared walls, and other issues that are present, but those really aren't implicated when the individual is outside their home and on their property, quarantining on their lot. So I think that's a great distinction that you've raised there, and one that's really important. I also want to, echo what Edwin has brought up, and I think what his discussion really showed to me is the balancing of interests that's crucial in these trying times, and it exemplifies an importance of balancing the interests of the owner, the infected resident, right? That's residing there, and the interests of all of the other owners in the community, and how we can all work together harmoniously. Because the idea here, as Edwin's pointed out, is communication. And how can we effectively communicate so that we can all, live and work together in a harmonious way? And another thing that Edwin has mentioned that I thought was really, pointed was that this is, an invisible virus. And so we also have to take precautionary measures throughout the community, even when we don't know of the infected person, such as maybe being respectful of the use of the elevators, right? Or wearing masks in common areas.
Great insight. That is perfect. Edwin, do you have anything else to add before we move on?
Jonathan's done a great job diving into both legal and operational, so I appreciate that. Taking a few words right out of my mouth there, Jonathan. Thank you.
So we'll move on to the next slide. We have a lot of residents who live part-time in New York, the hotbed of the coronavirus pandemic. When they come down, can we deny them access to their condo? And if not, can we ask these residents to quarantine in their units?
Yeah, I think these issues present a lot of legal and managerial operational issues. From a legal stance, right? What we're dealing with here is allowing them, not allowing them back in as residents in the building. And the short answer is yes, they should be continued to allowed to reside in their unit. In my opinion, to be clear, the local orders and the state orders in place that are currently effective do not restrict residents to continue occupancy in their units. That's not to say that an association can't reasonably establish legal restrictions that are more restrictive than those orders. But doing so in this context would really pose serious legal risks, financial exposure and liability. Um, so it's not advisable to attempt to prohibit a resident from coming back and residing in their unit. As to the second question about asking them to self-quarantine or to isolate, the answer is yes, they should be asked to do so, and they should be told that it's mandated now by the governor, but through the executive order. I believe the executive order is 2082 for the attendees to reference. And what that order provides is that in the New York tri-state area where there's substantial spread of the coronavirus, that residents coming into Florida have to self-quarantine or isolate for a specified period of time. And so asking them to do it, yes, we should. Enforcing them to isolate or quarantine, yes, we should. As a practical matter, how do we do that? And I'm sure you, May, and you, Edwin, are dealing with that, operationally in these communities, and can best give guidance on those subjects.
Thank you, Jonathan. From my perspective, again, I don't want to sound like a broken record, but communication, and it's actually gaining the buy-in of everyone in the community, right? And our staff, and just educating our residents, especially those that are coming in town from New York and other hotbeds, the importance of, looking out for their friends and neighbors as well. They might be asymptomatic, and traversing through the common areas, they could be putting everyone at risk. So, we ask that they work with us, right? Notify us and allow us to help support them during these days of quarantine where they have to self-quarantine and stay indoors and be home for those 14 days, and reaching out to us to see how we can better accommodate them to make their experience at home both comforting and let's face it, tolerable, right?
Some of our residents are facing financial hardships due to the pandemic. What can we do, or what do we need to do regarding move-ins and move-outs and evictions to abide by the law? And does the law require us to relax late fee and collection policies for residents facing these financial hardships? And to chime in with Jonathan's question, we have some properties that are wanting to prevent any units from being shown or even sold or rented out. Of course, we need to get, each community needs to get a legal opinion from their attorney regarding this, but what insight can you give us on that? And because I'm fearful that in preventing those, they're going to create more hardships to their communities. But again, it depends on the proximity and how congested that property is, and how close quarters everybody's in that building.
Yeah, I think that those are excellent, points and good questions, and they really raise the relationship, the interface between management and legal, and how we have to kind of work together through this crisis. The executive order, again, from the governor, and the actually it's not the local orders, at least in Dade County and Broward County, it's the executive order, which has an exclusion as it relates to real estate services. The exclusion is fairly broad. It's not specific. What it means and how it's implemented, I think, could be the subject of some legal debate. That being said, though, I think, precluding a move-in, precluding a move-out, taking an action that prevents the sale or taking an action that prevents a lease pose some serious legal risks. Number one, you may have a contract that's in place, so you may have that financial exposure. Number two, a person may be dependent upon moving into a particular property at a particular time. There could be a health need for it. And so that individual could be exposed to suffering some other financial loss as a result of the association's decision. So it is certainly important to tread cautiously, to consult legal counsel, and also to understand that there's really not a one-size-fits-all approach. I think that reasonable restrictions can be put in place to protect the residents and the health and safety during a move in and move out process, where again, we can continue to mitigate legal risks, comply with, executive orders, and also enable owners to freely transfer, their property without maximizing risk. So, or actually, rather to the contrary, the idea here is to limit that risk. I see that the next question, I don't know, I don't want to jump right into it right now. If there are still, any management or operational points, May or Edwin, that you may have on moving in and moving out and how that's working in these communities.
I will
Yeah,
turn
absolutely,
it over to
Jonathan.
Edwin.
Oh, yeah, okay. Thank you, May. But again, we want to work with our residents and fully recognize these are difficult times for everyone, especially financially. And so with that being said, we recommend establishing precautionary procedures, such as scheduling these moves, right? If you don't already have a structure in place, very important that you definitely work on your logistics, right? And reserving and dedicating an elevator to that move, scheduling dedicated security and cleaning staff, restricting egress and ingress, access and set traffic patterns for movers to follow. And very importantly, communicating these moves to our residents. They don't have to know exactly which resident, what unit is moving, but hey, there is a move happening on such and such date. During these times, you may want to avoid these areas, and reminding them that we are taking every precaution to ensure their safety and security, and what we've done to ensure that these movers and the move are isolated to certain areas that they won't come in contact with. And then, just offering that semblance of, hey, we're here for you, and we've got this under control. Let's be neighborly and accommodate this neighbor who's moving in or out, and welcome them or out of their community in a peaceful and happy fashion, right? So that's what we can offer on our end. On the HOA side, I'm curious, how is that accommodated, May?
You took the words right out of my mouth for that one. That was perfect. That is exactly what I recommend as well, because we're trying to help the residents, not and again, it depends on the situation. We want to help them and not prevent them from going on. We want to try to give them as much normalcy as possible. So if moving is one of them, then we need to accommodate. Jonathan, the next part of that question, if you want to jump into that.
So I think this is actually, a really important subject, and one that, unlike some others, will only increase in questions and developing dialogue with associations, and that's related to basically like the bloodstream of the association, the assessments, right? And we know that an association can't thrive without them. But we also understand, the financial hardships that people are facing with this crisis. And we also know that unemployment, unfortunately, is rising. And so with the crisis having started in, I'd say, really feeling it in South Florida, early March, right? Mid-March, we now are looking at this for the first time with the first payments for those that are on a monthly basis, with assessments coming due April 1st, right? And then there's some grace period there. And so really the extent of the impact on associations at this time isn't necessarily known. It may be felt in some respects, but not completely. And so I think that this will develop, and this dialogue will occur next month and the following month as well. We're not required to relax late fees, to answer this question. There is no legal requirement that we relax at this time late fees or collection policies in any association. That being said, for other reasons, we may desire to relax late fees and collection policies. For in the interest of the owners and that of the sympathy that we have, for each owner's respective financial circumstances. I think that it's important to, from a legal stance, really, to whatever gets implemented to be applied uniformly. in a consistent manner against all owners. And what that does is it prevents claims of selective enforcement or arbitrary enforcement, where we're doing one thing for one group or person, right? And we're not doing the same thing for another. And that serves to not only protect, management when management's engaging in, collection communication with respective owners, but importantly, it serves to protect the individual board members so that they're not accused of acting in an arbitrary manner. How do we develop these policies, and what types of policies? I think go back to, there's not a one-size-fits-all approach. And I think that each association needs to be specifically addressed, and their needs need to be, the policies for that particular association need to be implemented and tailored to the association. One association may have a rise of 5% delinquency rate. Another one may increase by 10% or 15%. Others may not have complete delinquencies. Others may just have requests from owners that have, specific hardships, and they have to balance what they can afford to pay monthly now versus what other expenses that they have. And so, there are payment plan options. Certainly there are, reduced or waiver of late fee options. But we want to carefully consider those options, because if we, for example, just establish a waiver of late fees for anybody that, is late during the next 3 months, what would that do for our community? All that will serve to do is reduce the late fees that we're going to collect, and it may not ensure that any of those owners that receive that benefit actually pay. So I think the idea in implementing an effective policy is one that is focused on achieving payment from the owner that they can afford to pay, right? And also giving them some relaxed, I guess, ability to make that payment. We also don't want to put ourselves, though, into a situation in establishing these plans and procedures that hurt the association. And so, when we go back to 2009 and the crisis that we faced then, some associations were slow to move forward, really slow, lethargic in the collection. And that hindered future collections for some of those accounts. They were behind the curve, they were behind the mortgage lenders, they were, they were unable to collect, and that, delinquency really turned into bad debt and a write-off. So there's got to be some careful consideration. I think that it's important for, the association's financial circumstances to be evaluated by management and the association's legal counsel collectively to best address and accommodate the owners under these circumstances. I'm not sure, May and Edwin, if you all have, started feeling this crunch in communities yet, or if you've had dialogue with your board members about developing policies and what should and shouldn't be done.
So we have had the dialogue. We have not seen any changes in our delinquency, and it's still early, but we have had the dialogue. We are also, we're preparing a revised budget in case the delinquency does increase. So we're looking at where we're cutting expenses to make up for that, so we don't see the financial hardship at the association level. But we have talked through that, and we've got plans in the works should we face those in our communities. What about you, Edwin?
It's really important, and our boards and our management teams, they're really in tune with their properties, right? They know their communities best, and recognizing that these are difficult times for everyone, especially financially, we're trying to be as proactive as possible and make the difficult strategic decisions for the best use of our owners' money, right? So you look back, Jonathan referenced 2009, right? 2009, 2001, we've all been through these difficult and trying times, and we've braced ourselves, we prepared. So knowing your community, what is the makeup? Primarily homesteaders, second homes, vacation homes, or investment properties. You should be able to understand your demographic and their means for providing or paying those monthly assessments. And equally important is reminding owners the importance of paying on time, because we're working off zero-based budgets. Now, hopefully your association is in a good cash position and has the recommended working capital of 2 months to offset hardships and delinquencies. But at the same time, it's about being proactive and forecasting cash flow in your positions, and looking back at your own your association's financial history. What happened back if you're in existence back in 2001 or 2009, and how did you react? And to Jonathan's point, were you lethargic? Were you too slow to react or respond? Who are the people that may history might repeat itself again with, and looking at those unit owners and preparing to have those conversations with them, and what you can do to ensure cash flow, right? So on management side, we're looking at expenses. Where can we reduce right now? Whatever possible, whether it's like electrical, gas consumption, water, any which way to just kind of harbor the funds that you have right now, just in case you do see an increase in delinquencies, whether it's 5, 10%. And then, of course, maximizing those dollars for the residents, and reminding them that, the money that we are receiving, it's being put to good use right now. You might not see a lot of activity, everything's closed, but making the most effective use of their funds and their money right now is really important too, and showing that, right? Demonstrating that through newsletters or weekly updates. Like, here's what we're doing with your money. Here's, you might think that, it's quiet and nothing's happening, but behind the scenes, we are reinvesting on your physical plant. We're taking this downtime to refresh and renew your property, your common areas, your amenities, so that, kind of like a spring cleaning, a purging of things, so that when everything finally reopens, you're welcome back to this sparkling, wonderful community that, looks as good as it did day one. So that's what's been really important for us as well. So not only being proactive in collections, communication again, but maximizing that dollar right now and hoping for the best and planning for the best.
That's great. And I completely agree with you. Move on to the next question. Are we liable if someone should claim that they were infected by the virus because of mismanagement of sanitation or social distancing at the property? So,
issues of liability really are determined by the judge or jury. And, as an attorney, my role in part is to provide my clients with sound legal advice to prevent liability, to minimize exposure and risks to liability. And that's why it's so important now to emphasize reasonable precautionary measures to help protect the health, safety, and welfare of all of the residents in the communities that we represent and that you all work with. The mismanagement and lack of sanitation and lack of social distancing all present real concerns and threats to a community on so many levels. And in these uncharted waters and unprecedented times in which there's really a dearth of legal authority on a lot of the subjects, I suspect we're going to see a lot of lawsuits, maybe not necessarily in the community association context, but related. I can see employer-employee lawsuits, maybe, right? Where there's a failure on the part of the owner to take efforts to mitigate risks, such as sanitization and cleaning, when we know that there's a foreseeable risk in the building. So the idea of implementing procedural measures to protect the health, safety, and welfare of the residents is really important, and will only help minimize risk and prevent liability. We're seeing it in all respects, not just in community living, but in projects too. Recently I'm dealing with an association that has ongoing construction, and there's a debate with the city on whether it should be closed down, because the city is receiving complaints from residents that the workers on site aren't heeding to social distancing guidelines, aren't heeding to sanitation requirements. and that the association's not doing anything, allegedly, to require those workers to perform. And then that creates a battle between the contractor and the association, another point of liability, right? Or potential liability. So the idea is, all of us working together to try to ensure that, the reasonable procedures that we do have in place are followed and adhered to, and that the association enforces them to the extent necessary, so that it's not a policy without bite. There needs to be some level of following through on this to ensure safety, or to assist in ensuring safety, as well as to prevent liability. I don't know if you all are dealing with, I'm sure more on the high-rise side, Edwin, you're seeing construction projects either ongoing. I don't know. I mean, are there measures that associations, like sanitization stations, what can be done in the community to help with that?
So yeah, thank you, Jonathan. Equally important, obviously, is process, right? Standard operating procedures, identifying those areas where, points of entry where you can install this hand sanitizer stations and trash receptacles, and marking paths on the floor so that you can direct the flow of traffic and where people should be going in and out, and marking, X marks the spot, where you should stand, and installing stanchions in front of your front desk to limit the distance between a resident or a guest and our front desk staff. Marking elevator, floors of elevators, right, with little X or footprints, so people know where to stand, to have an idea, understanding what that 6 feet barrier should look like. But also, documentation, right? So when we're talking liability, we're finding very important to document what we've done, what we've purchased, the areas that we've cleaned, the frequency, right? So having, for the most part, checklists for our janitors and our porters, our housekeepers, and timesheets, and understanding where our people have been, what have they cleaned, to make sure that we've touched every point, right, as frequently as possible, and communicating that to our residents and sharing with them, what have we done, what products are we using, how often are we doing it, what are we doing, on our part to control the spread, our means and methods, our frequency, etc. Letting them know that our staff is doing their part, but reminding them they need to do their part as well, right? So most importantly, stay at home, right? Limit their exposure, and understand that at any moment, an infected resident or guest or caregiver, someone can come in contact with a surface that we just recently cleaned and recontaminate that area. So really important to communicate that to our residents, and of course, going back to document and keep a history of what you've done, and also what you plan to do going forward. Those have been some of the things that I have seen that are really important right now, because we have been kind of hearing the word liability and claims being used a little more frequently these days.
Yeah, on the legal side, obviously, I want to mention also, I think that, supporting a claim that a person became infected because of mismanagement or lack of cleanliness, is difficult. So what kind of circumstantial evidence can they set forth to show, like you said, Ed, right, that we contracted the virus even though you cleaned it one day and it became infected the next by somebody who unknowingly touched it and unknowingly had the virus? And so, the evidence that they might be able to put forth in that respect may be tenuous, but again, the idea is the courts are open, lawsuits can be filed, and, association board members have a fiduciary duty, and we should all they should carry out those duties in the best interest of the owners, and to implement reasonable measures to protect. I think you raise a great point about documentation. I think that that's highly important and highly recommended. And I think that along those lines, each board needs to consult, FirstService, their management company, their attorney as well, as to communicating some of the policies and procedures and regular updates with their owners to demonstrate the proactive measures that you've mentioned just now, Edwin?
So what I'm hearing, the three things I'm hearing is communication, education, and documentation. And that's going to help us out a lot should a situation arise with a lawsuit. Is that correct?
Oh, absolutely.
Perfect. 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 So great job with that one. Okay, so on to the next. What recourse does the board have if residents choose not to comply with practices that the board mandates? For example, visitor policy.
So addressing that example, we've got, there's the idea of internal and external remedies. Internal remedies would be those kind of enforcement measures that an association can normally take. Those would be, I think, of limited enforcement, now. I mean, really suspending the use of a pool or the gym or other amenity, it's already closed. No one's using it. So if they're violating a guest policy, it's not going to prevent them from continuing to violate it. Fining, I don't know of any committee members that are going to want to attend a committee meeting if it's in person. But yes, they can be held over the phone. But, we're really capped on our ability to fine, right? Florida statutes places a cap on the amount of the fine. There's also procedural elements that are required to comply with in order to impose the fine and to levy it and vote on the imposition. So what I'm seeing really is just enforcement through legal means when necessary to require compliance. And that's either in the form of an emergency action for injunctive relief, or just through, if it's not an emergency, just through filing, an action for an injunction to require compliance by the violating resident, whether it be a tenant or a unit owner. There are the enforcement measures may vary depending on the type of violation, right? So if we're looking at a violation of a failure to quarantine, some of these orders, these local and state orders have enforcement measures built in, such as the quarantine requirement from the New York tri-state area order imposes a violation as a second-degree misdemeanor punishable by imprisonment or a $500 fine or both. And so law enforcement can be included in the enforcement measures. I can tell you, for example, in the city of Miami, there's also the stay-at-home order that's in place. And so I believe that order also has a penalty provision in it. To the extent that law enforcement is capable of being involved and has the resources to be involved, certainly they should be notified of violations of their order, whether it's this sort of travel throughout the city to get from point A to the association, or the not adhering to a curfew that's been imposed. But this slide really also presents practice pointers from an operational and management stance. I think that an association that's considering to legally establish new policies and procedures needs to also focus on how do we implement those, and what can we do to better operate during that implementation. So May and Edwin, if you want to comment on those points, that'd be helpful.
So I'll take this one, May, for the time being. Jonathan, great, valid points. And, one thing that I have been promoting heavily with our managers is, just reminding our residents that they've chosen to live in a community structured with rules and regulations set in place to promote the quiet enjoyment and harmony amongst each other, right? And our boards are making these difficult decisions almost daily that impact them as well. And these policies and procedures and mandates are being established temporarily for everyone's safety and security. And hopefully soon, someday, we'll see them lessened, if not altogether removed. But it's equally important that our residents cooperate, and if necessary, see something, say something, right? So that the board and manager can address those individuals in a non-confrontational way. Again, these are our communities. This is where we live. And we don't want to make things uncomfortable for anyone, right? Because these are neighbors you're going to live with for some time. And so, helping them to understand the importance of compliance for the safety of themselves, their families, and that of their friends and neighbors is of the utmost importance. And that's the approach we've been taking. And again, we don't want to be placed in an adversarial situation. We don't want to have to put together fining committees or hold committee meetings to address these things. We definitely, the last thing we want to do is have to call law enforcement on one of our own residents. So this is the approach we try to take, right? The neighborly approach. What do you think, May?
I completely agree. And it's not just for their safety, it's for everyone around them. So yes, I 100% agree with you. Even in HOAs, we have some guidelines that they need to follow, even though they're more separated, but especially in condos and high rises, they chose that lifestyle and they need to be aware of their surroundings and protect each other. So you're absolutely right. Okay, so that's all the time we have for today. On the screen, I have a few key takeaways that we discussed. Jonathan, do you want to add anything else?
I'll just reiterate that we are facing some, unprecedented legal issues here, and, operational issues. And so it's important that while, I'm not giving legal advice to anyone in particular during this presentation, that each board consult their attorney as they move forward in making these difficult decisions that they're faced with and implementing, reasonable policies given the specific community in which they live and the specific challenges that each particular community faces. I think that this, conclusion slide presents, a good summary of some of the issues that we've discussed. The only thing I'll mention is the order, if I can locate it quickly, which is the one that we've talked about a few times relating to the New York tri-state area, and that's Executive Order 2082 for reference. Thank you, May, and I also want to say thank you. It's been a pleasure to present with you all, and I hope that this webinar is helpful to everyone.
Thank you so much, and thank you for joining us, Jonathan. Edwin, is there anything you wanted to add real quick?
No, thank you, May, and thank you, Jonathan. I really appreciate and enjoyed this time interacting with you and answering our board members' questions out there. And hopefully we've been able to adequately address and not only that, but give them some great advice and pointers to moving forward, and give them that semblance and assurance that they're doing the right thing, and keep it up. These are difficult times and very stressful, and as leaders of their communities, there's a lot of weight on their shoulders, but as your partners, we're here for you, and just want you to remember that. Thank you.
Thank you, and I couldn't agree more. So thank you to both of you. This information is tremendously valuable for our board members and our professionals. I have a few resources on the screen. It includes an email address where you can send any additional questions that you have. We thank you so much for participating in our webinar. Please keep an eye out for more information on upcoming webinars. We believe our COVID-19 Your Questions Answered webinar will provide valuable insight that you and your fellow board members can put into action in your communities. I echo what Edwin said earlier. We thank you so much, board members, for your leadership in your communities and for being such valued clients of FirstService Residential. Goodbye for now.